Hello viewers from wherever you're watching us from. You're watching QTV, the Gambia's first private TV station, and we are broadcasting live from our studios here on Kairaba Avenue. My name is Ali Osise, and it's now time for your weekly State of Affairs program, where this week I'm joined on the program by lawyer Abdullahi Fati, who is the Secretary General of the Gambia Bar Association. In the next 55 minutes, we'll be exploring the mandate of the GBA, but equally, what role do they have in upholding rule of law, among other issues? We all know what has been happening as far as the judiciary is concerned. We'll engage him more to understand, what their standpoint is as far as these issues are concerned. Once again, Lawyer Fadi, thank you so much for coming on the State of Affairs program. Pleasure having you on the program.
It's a pleasure to be here, Ali. Thank you.
For viewers who may not be familiar, start by telling us exactly what the Gambia Bar Association actually what exactly it is and what does it stand for?
The Gambia Bar Association is actually one of the oldest legal professions on the continent in Africa. It's a collegiate legal body, a professional body that regulates the affairs and the conduct of legal practice of lawyers, look after the welfare and the interest of our members. That is at the micro level, but at the more macro level, the bar is also invested and concerned with promoting and strengthening the rule of law, respect for fundamental rights and freedoms, democracy, and some of those basic international principles.
And like you said, it stands to ensure, the welfare of your members are respected. Who are these members?
Our members are individuals who have satisfied the requirements and ultimately become legal practitioners. So in simple terms, these are individuals who would have gone to university, done their basic university degree, would have gone on to do their bar vocational course, which you do your degree. After your degree, you do your bar vocational course, and that is the bar course. Ultimately, upon passing your bar course, then you are called to the bar here or any other jurisdiction. But that doesn't actually entitle you to practice immediately. So in the Gambia, for example, so you do your degree, do your bar, pass your bar, and upon being called to the Gambia of the government, and we'll say the Bar of England and Wales, to the Gambian bar, then you embark on pupillage. So this is where you are either at the Ministry of Justice, but 90%, or I'm guessing 85 or 80% of young people who are just coming out of bar school work in chambers. So it's basically like an apprenticeship where you spend 12 months in chambers and you learn the ropes about going to court, how you interview clients, how you prepare summons, pleadings, basically the conduct between lawyers and client, and preparing court documents, but also drafting agreements, lots of other things as well. So upon satisfactory completion of that, then you are enrolled. Upon enrollment, this is when you're given certificate to be able to practice as a fully fledged legal practitioner. But even then, there are certain things that you cannot do. For example, to appear at the Supreme Court, for example, takes a few years, in which you would have accumulated a certain level of experience to qualify you to appear, for example, at the Supreme Court. So it's a learning process, but even for people who've been doing this for many, many years.
So as we speak, how many members do you have in your association?
It'll be difficult to give you a precise number, but in the hundreds. Because every year we are, because of the, now that we have a university and a law school in the Gambia, we're producing a good number annually. So it will be in the hundreds.
So is it compulsory that anyone who is into the legal profession has to be a member?
You have to be a member of a professional legal body. In the Gambia, the recognized one, well, we all know, is the Gambia Bar Association. But as long as you are a member of a professional legal body, you'll satisfy the legal requirements stated in the Legal Practitioners Act.
So, is it purely just a professional body like you mentioned, or you also kind of play that public advocacy role?
Okay, so traditionally, for example, because this is like a trade union sort of professional body, so you're looking probably more micro level. Perhaps one will think that the bar will be more concerned with the welfare of members, sort of like welfare members' interest, and sort of like managing those affairs and how what lawyers are able to do, what they cannot do, sort of that regulation aspect of it. But if you look at now, as the world advances and you look at the relationship between society and the law, the relation between law and society, the law between law and environment, law and, for example, development, then you are able to see, for example, the connection and the nexus. And therefore, for example, the Gambia Bar Association strategic document articulates the relationship between the bar and society. For example, apart from our core mandate, which is member-based sort of affairs, but it's also part of our primary responsibility and core responsibility to make sure that we ensure that we promote the rule of law and make sure that the rule of law is respected within our governance system, and also promote the respect for human rights.
We will get to how you ensure that the rule of law is upheld and respected. How does the GBA kind of differ from the judiciary or the Minister of Justice? Just make us understand this.
Okay, all right. It can be a little bit difficult to understand. Okay, so the Ministry of Justice is part of the executive arm of government. So the Attorney General and the Minister of Justice is the head of Ministry of Justice, and their role primarily, well, the role of the Attorney General is to advise government, is the principal legal advisor. But apart from that, you also have the Director of Public Prosecutions, who is part of the Ministry of Justice, and they embark upon prosecutions. So there are two entities in the Gambia that do prosecutions: the Inspector General of Police, the IGP, or the Attorney General's chambers. The police normally deal with some of the lesser offenses, misdemeanor, assault, and stuff like that. So when it comes to offenses like rape, murder, terrorism, and arson, and treason, and all of that, these are prosecuted by lawyers from the Attorney General's chambers. So that is the one. So they're part of government. They are vehicles of GG, and primarily their function is to prosecute. Then you have the judiciary, which is not part of the executive, but it's another independent arm, one of the three branches of government. You've got the legislature, which is the National Assembly. Then you've got the executive, headed by the president. And then you've got the judiciary. So the judiciary is it. That's why the judiciary vehicle do not even say GG. Because this is just to sort of like, even in the optics of it, to show that the judiciary is completely and wholly independent, even though it's part of the broader government machinery. So the judiciary's function is to adjudicate, so basically judge cases. So in the midst of all of this, the bar is just a stakeholder and one of the institutions within the rubric of the justice system. So our members include, well, in order to become, you would have become, or you would ordinarily be a member of the Gambia Bar Association before later on you become a judge. So every judge, every lawyer in the country, whether you are actively or otherwise, but you are inherently a member of the Bar Association. So if, for example, the medical and dental association, so anybody, so whether you are a surgeon or whatever you are, at some point you would have part of that. So it is part of the professional collegiate bodies. But if you look at our members are at the Ministry of Justice, so they prosecute. But you also have our members who, like myself and others who are in private practice, who defend, also prosecute matters in criminal. So, but you have all these different institutions within the justice system.
So when does one sister become a member of the association?
Well, it is not compulsory that you must be a member of the Gambia Bar Association, but it is compulsory that you must be a member of a professional legal body. Well, if I don't want to be a member of the Gambia Bar Association anymore, I believe I can write to say I don't want to be. But but there are still requirements. If I don't, in order to be able to have a practicing certificate annually, this is issued by the General Legal Council. Yeah. So the General Legal Council is different from the Gambia Bar Association. It comprises of lawyers. Yeah. The Attorney General is of the General Legal Council. The chair is the Chief Justice, and I think 3 other people from government, essentially. So they regulate in terms of discipline and also some of the regulatory aspect of the work. But in order to cease, I think technically, if you don't pay your dues, one may argue that you may, by default, be stripped of the benefits that one would ordinarily enjoy if you were a fully fledged and paid up member. But we hope all lawyers in the Gambia will take pride in being members of the Gambia Bar Association. Which is fair enough. I mean, which is fair enough. If you're part of an association, you must, commit yourself so that you're really committed to what it stands for. Let's now look at, your role in upholding, the rule of law, like you mentioned earlier on. How does GBA contribute, to strengthening the rule of law in the Gambia? In so many aspects, but in terms of our individual work as lawyers, you go to court, you make application on behalf of clients, but sometimes pro bono, they say, well, this is not in line with the law and this is how it ought to be. Pro bono here, free. Free, yeah. So when that happens, even though we're doing this on behalf of our client, but more broadly, when the courts decide on these matters, ultimately, the consequence is that it promotes the rule of law. 2 years ago, for example, the Gambia Bar Association, this is one aspect of it. For example, access to justice is also part of our core mandate. The GBA traveled the length and breadth of the country. We went to every region, all the 5 or more regions in the country. And at each region, we went to a school, we went to markets, we went to schools, community centers, community radio stations to sensitize the public about basic, women, their rights, pregnant women, maternity leave and stuff like that. All of that. So people, know more about basic rights. But in terms of upholding the rule of law, apart from, like I said, our work individually as private legal practitioners, but the bar in itself. Remember in 2016, after the elections, and when the former president unilaterally sought to annul or reverse the sovereign will of the people, the bar met, released a statement on behalf of the public in order to preserve the constitutional order as demonstrated by the people's will in the elections. And that was the catalyst. Everybody came together to condemn what we believe was somebody trying to usurp the will of the people. That is one, for example where it demonstrates where the bar playing its public role. But more recently as well, where people know or not, even when bills are being passed in Parliament, we are invited, we have sessions with the different committees to try and sort of enlighten or have dialogue with our lawmakers, to try and achieve best international standards so far as whatever law is being passed. But whatever is happening, we're part of it. But we have a lot of dialogue with government departments, with the police, with the MOJ, with the judiciary. And so we participate in lots of activities, and with the objective of ensuring that at all times within our governance system, that the rule of law is central and integral and respected and upheld, and human rights and freedoms and all of those things, like you would expect in a democracy. And what role do you play in protecting the judicial independence? Well, by making sure that the executive or other branches of government do not encroach or do not sort of interfere with that. And when that happens, for example, we speak, and so I cannot think of an instance right now, but whenever there has been an instance where we believe that there may be a potential conflict of separation of these powers of the different institutions of the state, the three branches of government, then we intervene. Sometimes we intervene, when the public is not even aware of this. Sometimes we intervene and we are able to get results. It's not all the time that you publicly come out and stuff that we, but even more, apart from those ones where that, some of the things that happen in private, we've been engaged in lots of high profile public where
Can you give example? Can you give example?
I can think of, okay, for example, in 2020, December 2022, when the bar had that, for example, there was a ruling by the High Court. I can't remember, is it Global Homes or something, I can't remember, where there was a High Court order for government not to do certain stuff, activities. And it appeared that steps were taken that had the potential to undermine or interfere with the court order. But the bar wrote to the Solicitor General. That didn't come out publicly, but they wrote to the Minister of Justice, particularly the Solicitor General, to say the sanctity of law in terms of respect for judicial decisions, that whatever if you're not happy with, then that's why we have this appellate system. If you're not happy with something from the Magistrates Court, you appeal the High Court. If you're not happy with something at the High Court, you go to the Court of Appeal and ultimately the Supreme Court. So these are some of the things that we do. It's not all the time that you come out and sort of like go on the radio and release a press statement, but that is one example where we intervene to say government ought to be careful that whatever government does has to be within the confines of the law, particularly any action that has the potential to undermine judicial, the credibility of the work of the judiciary.
So does the GBA have enforcement powers in any way?
No, no. Well, the only enforcement power that the GBA does is to probably go to court as an institution. But over than that, we believe that there is mutual respect between the different. So when we speak, we would like to think that government will pay attention because we are not political. We're just simply here to make sure that the rule of law is respected and upheld. And we would like to think that sometimes there may be disagreements, or we may think things that we say, hang on a minute, if you do that, it may have the potential to undermine our democracy, to undermine the rule of law. And therefore, sometimes when you speak, privately or publicly, then public government will appreciate where the bar is coming from. And I think, that is one example, but there are other instances where the bar had intervened.
So beyond lawyers, I mean, how does the GBA actually serve ordinary Gambians? I mean, ordinary Gambians, beyond just, your members and, trying to ensure that, there's that judicial independence?
Okay. So judicial independence and for ordinary people. So what we'll do for ordinary Gambians will be to enhance their access to justice. Female Lawyers Association, although it's independent, but their members are members of the Bar Association as well. The FGM case is before the Supreme Court. The GBA is that, is part of that, those efforts, for example. But in terms of judicial independence, but I have to emphasize here that since 2017, that the judiciary has been doing a remarkable job, considering how sort of Yahya Jammeh decimated the independence of the judiciary. We have to admit this. But since 2017 to date, the judiciary has been remarkably independent. The judiciary delivered loads of judgments, high-profile judgments. I wouldn't say against the state, but they're just simply applying the law. And that is what we want, So this is not like a football match where you're saying, well, government is winning or government is losing, stuff like that. The judiciary and all of us, when we go, it's not like a ping pong where there's ultimately a winner or loser. We just simply want to make sure that the law is upheld. And if the judiciary does that independently, then that strengthens our democracy. But from 2017 to date, the judiciary has really demonstrated that it is independent, that it has complete control over what it does, especially in terms of its judicial work. And this has manifested in so many cases that ordinarily people may say, well, these are political cases. Yeah. But where the judiciary is turned around to say, well, this is the law, and maybe the government action has fallen short of the law and pronounced against government.
So, I mean, how do you engage with the civil society as well?
Well, so if you look at, for example, the bar now, maybe 40 years ago, 30, but if you look at the bar now, we would like to think that we are part of civil society. We work very, very closely with civil society organizations. Every week or so, we are invited to workshops to help expertise or whatever we engage. But we work very, very closely with civil society organizations in terms of accountability, in terms of transparency, in terms of victims for the TRRC, Transitional Justice Project, and lots of others as well.
So, I mean, what is your stance, I mean, as far as the issue of, I mean, the legal aid and, of course, affordability in terms of, I mean, legal services in this country?
So you've got the Legal Aid Act, I think it's 2008, yeah, which created, or maybe even earlier, but we have NALA, National Agency for Legal Aid, yeah, which is part of government. So essentially people charged with certain, so right now I think it's arson, treason, rape and murder, capital offenses. Then if you're unable to, if you cannot find your own lawyer, then the state itself from NALA would provide you a lawyer to provide you a defense. Well, people that work in NALA are members of the GBA. So the current president of the Bar Association was the chairman of the NALA, yeah, I think up to 2 or 3 years ago. So you can see how all these things are interconnected. And we applaud the work of NALA, just like any other institution within this circle of justice sector institutions. It's working independently, but we all corroborate to ultimately achieve justice.
Let's now look at the internal governance and professional standards of GBA. I mean, just share with us, I mean, how do you regulate, I mean, the conduct of lawyers in the country?
Okay, so there are, I don't want to be technical, but there are so many aspects and so for example, there are things that we can do, there are things that we cannot do. Lawyers cannot advertise. Okay. For example, we are prohibited from advertising. Oh. Yes, we cannot do that. Okay. So unlike other things when you do it, we cannot do that. I cannot,
Yeah, exactly. Yeah.
We cannot do that.
Yeah.
We are also prohibited from speaking in relation to cases that are pending, that are ongoing before the courts, so as not to interfere with that process. So there are lots of things. But when it comes to another dimension of it is the general legal counsel. So for example, if a client believes that there's a professional misconduct, that client may write to the Gambia Bar Association, and what we will do is to refer it to the general legal counsel that has the jurisdiction to sort of like sit over that as a disciplinary component, okay, of that. So it's an independent body. Its membership is derived, like I said previously, from the GBA, from the Attorney General's chambers, from the judiciary, and from government. And its powers are also derived from the Legal Practitioners Act.
So like you mentioned, I mean, what are some of the mechanisms that exist for disciplining members who actually violate your ethical standards?
So there were times in the past when certain individuals may have done certain stuff that may have fallen below the standards. Yes, but I'm aware of once or twice in the past where a certain member was disbarred, maybe where a certain member was disqualified for a certain period for probably being involved in an activity or a conduct that compromises the integrity of the profession.
So are there current challenges in maintaining the standards?
Yes, there are challenges. Obviously, we are having more and more lawyers. Okay. And the more and more lawyers you have, then ultimately, naturally, then you'll have probably more and more complaints and become more and more litigious. So if you go back to probably 40 years ago, you can count the number of lawyers we have. But you can also count the number of cases that we had in court, but you can also count the number of people that sought the advice or the work and the services of lawyers. But now we are at the point where even if you want to buy a mobile phone, you want to engage the services of a lawyer. And ultimately, because of this expansion in retaining and securing the services of a lawyer, then along the way there'll be cracks that may clients or the public may adjudge to fall below the standards ordinarily required of lawyers, and they will complain. So you'll find out there is ordinarily a spike in complaints or people who are dissatisfied with work of lawyers. But it's natural. But the GB and the General Legal Council takes these complaints very, very seriously. The legal profession is rooted in centuries of tradition of fiduciary responsibility, responsibility to uphold the truth. So when lawyers, even in their own communities, society expects lawyers to behave in a certain manner, to uphold the highest professional, ethical, and personal standards. And therefore, we as a professional body encourages and implore all our members to conduct themselves, both privately and publicly, in manners that do not compromise the respect attached to the name of legal professionals.
So with all this, what will you point to or describe as the biggest challenge currently facing the legal profession in the country?
It'll be difficult. Challenge facing the legal profession.
Yeah, the biggest. I know there are many, but the biggest that you will say this one deserves
of legal professionals.
Yeah.
Probably our court system.
Oh, okay.
Backlog of cases. I think if you speak to any lawyer, I think probably the most immediate concern is that how long it takes for cases to be determined and disposed of in this country. And again, all of us, all the stakeholders in the process bear a certain level of responsibility. Cases take an awful long time to litigate in our courts. Courts are inundated. Some judges have at least 150. You go to certain magistrates' courts, they preside over at least 20. So because of all of these things, I think then all of us collectively and individually, institutions, there are lots of things that we can do better. But I think the biggest threat and challenge right now is probably delivery of service within our court system.
So what will you say are the gaps in the justice system that really concern,
capacity,
the Gambia Bar Association?
Capacity, tools both in terms of personnel, in terms of, so for example, if you go to 99.1, apart from 2 or 3 courts that I know, as I'm talking to you now, if I were making these, like for example, if we were making oral submissions, if I were speaking in court, everything I've been saying, imagine this has to be written manually by a magistrate, by a judge. So that in itself, but 1 or 2 courts now have started using technology. So you just pick and it's recorded and transcribed later on. So it just speeds things up. So those are some of the things as well. So you go sometimes and there's probably no interpreter, or the clerk has classes, it's gone to university and it's not. But so some of these small things here and there sometimes disturb the cases from flowing and proceeding smoothly.
So how do you engage, government to address some of these concerns?
Well, this is not government's problem per se. Okay. Well, it is more broadly, but it's the judiciary. And when we have an interface with the judiciary, we raise our concerns. They also raise their concerns about lawyers, for example, that they may say lawyers probably take more cases than they can handle. For example, they may have other, things that they may, certain complaints. But we also have complaints to say, well, I think we have to look at these things, lack of transportation for judicial officers and stuff like that, manpower and lots of other things as well. But when we engage the relevant authorities, we relay these informations and we try and work together to see how we mitigate some of these challenges.
Is there any alternative to have some of these cases settled out of court?
Excellent. And this is the reason why we have the now court-connected ADR. So the ADR is the Alternative Resolution Service. So we now have the court connected. But apart from that, the court also introduced the new rules, I think, in 2022. So apart from certain cases, maybe certain human rights or constitutional matters, but 99% of cases, before you go to court, you must engage the oversight. You must tell them why you are aggrieved and what can be done to settle the matter out of court. If that fails, having attempted to settle, then you can go to court. So that means the first limb to satisfy would be to engage the other side, try and settle. If that fails, then you can go to court. But even if you go to court now, for civil matters, the courts, more often than not, will refer it to the court-connected ADR. And since 2020, I think 2023, we've had a lot of lawyers, but non-lawyers as well, practicing active lawyers, but others people who are within the justice sector, professionally trained as mediators and are now certified. So, for example, actually, on Wednesday the 9th of this month, I have an ADR, I wouldn't say hearing, but ADR sort of like meeting between my client and the oversight, where both sides, and lawyers really play a very minimal role in this. This is actually for clients. Okay, so this is away from court in a more probably friendlier environment where the parties can dialogue, trust out what the common areas are, what I mean, the areas that are not in dispute, the areas that are in conflict, and to try and narrow it down and agree on what can be agreed upon, sort of like, and there's been a very good success rate for this. So this is just one aspect where a challenge has been recognized, a remedy or an intervention has been put in place that has yielded positive results.
So how independent is the association from any form of political influence or state pressure?
150% independent. 150%.
Okay. I mean, 2026 election is coming up. I mean, as we head to the polls, I mean, what exactly, I mean, or how is the Bar Association in this case, I mean, trying to ensure that everyone play by the rule of the game and ahead of the election?
Right. So as we progress more into the fever pitch election period, at different stages, there will be different stages and different programs and policies or whatever. And at each time, the bar as an independent bystander, but an interested bystander notwithstanding. And if we see anything that we believe fouls the rules, then we will intervene appropriately at that particular point. Because our interest is that because free, fair, credible, transparent elections are all part of the rubric of the rule of law. It's part of the principle of the rule of law. So if we believe that there's anything that undermines that by anybody, whether anybody for that matter, anybody, any active player, then the bar will respond or react accordingly at that particular time.
So what reforms or initiatives are you prioritizing at the moment?
One of the key, the bar's key interventions right now. So previously it was the draft constitution. The bar really wants a constitution that reflects our current democratic aspirations. Unfortunately, we all know what happened last year. But we were involved in that. But we continue to be involved in that, even behind the scenes, in different fora. As of today, it just depends on what particular issue. But for example, I'm sure you are more familiar with this than I am, the new media content regulation and stuff like that. So
the controversial regulation that.
Yeah. So the GBA been a guardian of the rule of law. Is corroborating and working closely with other civil society organizations during this outreach period that PURA had laid out to come up with a position that supports our democratic aspirations, but also to make sure that whatever happens, whatever regulation, whatever law, whatever policy is advanced by government, that it is in line with international best practices and the Constitution and other statutes. So that, for example, we are working with our colleagues right now, and at the appropriate time during this consultative program that we're engaging with our colleagues, and our position with, alongside our colleagues will be communicated to PURA or any other relevant government authority.
Some critics say your association only reacts to high-profile cases. Just tell us, to what extent is the bar obliged to speak, out on matters like we have seen recently on the Ousseynou Bojang's case?
Whenever there is anything that undermines the rule of law, the bar is obliged to speak, whether this involves somebody from Sarebojo or from Banjul or Serekunda, regardless of one's education, background, financial status, otherwise. So our interest is primarily to uphold and promote the rule of law, and that is the more reason why we released a statement in the... Okay, so there may be others that we may not say anything because we're not probably aware of. Because, for example, in Sarebojo, if a farmer is arrested and is detained beyond 72 hours, we are not aware of it, then you cannot speak. But where we are aware of these things, but it's not all the time that you also speak publicly. You may intervene privately, but still to make sure that the desired results are achieved.
You've issued a press release following what happens following the release of Ousseynou Bojang and his subsequent arrest. Take us to the press release. What is your standpoint as far as this matter was concerned?
Well, standpoint is very clear, as expressed in the media release. The release was to remind government that whatever government does, especially judicial independence, and we also have to look at the history of our country. Under Yaya Jammeh, the machinery of government was controlled by one individual. Judges were hired and fired
anyhow
at one person's will, without adherence to the prescriptions laid out in the Constitution or statute. 1, 2, or 3 chief justices, the most senior lawyers and judicial officers in any country, sacked simply because Yaya Jammeh disagreed, was unhappy with their judicial decisions. And that just tells you how terrible it could be for a judge to be sacked for simply doing their judicial work. So the essence of the press release was to remind government that it is utterly important to ensure that whatever government does, that it is in line with the law, that cannot be in any shape or form disregard for the rule of law. In the Ousseynou Bojang case, there was a judgment. There was an order granting bail. The following day, pursuant to that court order, these individuals were released from mile 2, pursuant to that court order. At that particular point that they were arrested, there was no court order. There was nothing whatsoever. So to put this in context, that means there is a valid court order saying A, B, C, D. 18 hours later, despite the fact that there is a valid and subsisting judicial court order, not least by the High Court, certain government institutions, in this case the IGP, but I'm guessing working very closely with the Attorney General, Minister of Justice, that these individuals who were released based on a court order. So that means that despite the fact that there is a valid court order, actions were taken that completely disregarded a judicial order. So that is, I cannot think of anything that is more serious than that, because if government itself begins to act in a manner to say, we will take the law in our own hands, we are not happy with something, but because we are government, we are powerful, we will go behind the back, then what if ordinary people are taken to court and prosecuted and convicted, their family members cry, okay? They don't go and attack the judiciary, they don't go and attack the police, they don't want, but they accept their fate, because we have established this system hundreds of years ago, that we have a system where if there is a conflict, we've created this institution called the judiciary, and as the arbiter between the person who's complaining and the person who's been accused. And in our system of governance here, the Constitution and various laws has entrusted that responsibility to the judiciary. And in this instance, a High Court judge, end of the proceedings, the state mentioned its intent to appeal, relied on a provision from the Criminal Offences Procedure Bill Act. The judge listened to both sides, had wisdom with both sides, and came up with a decision, a ruling, to say A, B, C. If you're not happy with that, there are legal ways how you deal with that. What you ought not to do is to undermine the authority of that court.
So, I mean, I just want you to make us understand, from what legal justification, I mean, could the state in this case rely on for rearrest in such circumstances?
I don't think they were rearrested, because if you're arrested, you are told exactly what you've done. Yeah. In this case, I think they were simply detained. Because when you arrest somebody, you tell them, the law requires you have to tell them exactly what they have done. But in this case, all that we saw in the press release by the state were that they were appealing, they were not happy, blah, 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 and the rest of it. So I don't think they were, because when you arrest somebody, you tell them you arrest, they tell them, I'm arresting you on suspicion of committing a crime. But in this case, I don't think they were arrested. I think what happened, they were simply detained in violation or in breach of a court order. If the state believed that releasing these individuals posed a risk to society, appeal is a right. And that was mentioned in court. And we have to, you know, and respect has to be extended to this appellate system. So if you're not happy, you appeal and goes all the way to the Supreme Court until we get a final determination. So the state appealing is absolutely, there's nothing wrong with that. You appeal, but if you also believe that these individuals or another individual, for example, this was another case, and you believe that the release of those individuals poses a certain risk to society or certain security risk, But this was actually mentioned in court. The judge heard what he said, but still came up with a decision based on what was presented. Because remember, if you turn around and say, well, I believe that Ali will do A, B, and C, you have to prove. Because, like I say, the law doesn't work on suspicions or on conjecture. It has to be something that is tangible. But in this instance, for example, without getting so much into it, but I think the appropriate course of action would have been an application for the court to vary the court order, the bail condition. So, for example, if you think 50,000 was too small, make an application. Make an application urgently. So that means the same day you would have drafted this, first thing in the morning, file it with a certificate of urgency, let it be had immediately before the release. So in the affidavit accompanying that application would be things like, whatever you believe. We believe that there is a risk. We believe D, B, C, D. Ablai Fati is a mercenary. Ablai Fati was trained in Libya. Ablai Fati was a jungler. Ablai Fati is capable of this. And we ensure you Ablai Fati was convicted of terrorism, blah, blah, blah. All of those sort of things.
You must be able to convince the court beyond all reasonable doubt.
That in this particular instance, releasing this person without certain layers of protection may pose a certain risk. So, for example, you do all that. Let it go before a judge. Before even, so this would have been done first thing in the morning, but that didn't happen. So what happened here is between 11 a.m. and 12 noon, these individuals were detained. Then at 3:50 in the afternoon, so you detain them at between 11 and midday. 2, 3, 4 hours later, you then go and file an application. But even the application filed was just simply an ex parte. No, I don't want to get into so much of the stuff, but I think there was a lot of it that really, in all honesty.
So I mean, what precedent does this case in any way set for our country's future criminal trials?
But this case is not, well, before I even get into that, we have to remember that in the midst of this chaos and conflicting positions, 2 young Gambian servicemen in active duty, in uniform at night on our streets to keep you and I safe, brutally killed in cold blood. A third person also
injured,
shot, but recovered.
Still recovering.
So it's still recovering, and will recover for the rest of her life with the psychological trauma. So all of us are victims in this because they were wearing the Gambian uniform, protecting Gambian people, and everybody on Gambian soil. So let us remember them. Let us pay tribute to their ultimate sacrifice for our country. So we should not lose sight of that. But despite all of that, and therefore the more reason why, it is prudent that the perpetrator of this really grotesque and heinous crime is accountable. So perpetrator or perpetrators to be held accountable for what happened. But at the same time as well, we have a criminal justice system that says that anybody, regardless of background, creed or color, education, whatever, anybody taken before a court accused of a criminal offense, there is a certain burden on the state to prove that case beyond reasonable doubt. Reasonable doubt doesn't mean any shadow of a doubt, okay? But the doubt has to be so reasonable as to say that in this instance it will be unreasonably and unsafe to convict this person. The judge who had the case arrived at the conclusion that the threshold for securing a conviction was not satisfied. But the state has appealed. So let's allow the appeal process to take its course. But ultimately, we hope that the perpetrator of this really heinous crime is held to book.
So how important is it for our security agencies to strictly comply with court ruling?
Okay, Section 19, if I'm not mistaken, of the Constitution, Chapter 4, deals with fundamental rights and freedoms, or 17, one or the other, said that the executive and all organs of the state should assist the courts in their work. Because remember, the judiciary doesn't have police. Most of these things are done out of goodwill and good faith because of the system that we have established. Okay? The system that we have established is that when a police officer stops you in traffic, you stop. Even at night, you can run and go your way. But the law we've established that if they ask you to stop, if they ask you to come out of the car, if they ask you to produce your license, you produce it. You abide by those orders because those are the rule-based orders that we've established as in any civilized country and democracy. The state in particular, here the police, Attorney General Chamber, and all of the state, it is important that sometimes, but even us as private lawyers, you go to court, at the end of the trial, there is judgment, you're not happy. You believe that the judge, that particular judge may have gotten the law or the facts wrong. But you don't stand there and insult and whatever, or go and attack that person. You don't do that. What you do is you appeal against the decision to the next court, and the hierarchy you follow and ultimately entail.
2 days after this ruling was made, and we saw what subsequently followed. I mean, we saw the chaos here and there around the group, and we have had the president made a statement in which he said they still maintain, or they still suspect and believe that this crime was committed by Hussein, who was accused and discharged by a competent court. What's your take on this statement by the president? Do you think it was right for him to make certain statement at this particular stage?
While I acknowledge the president admitting that he respects the decision of the court, but disagrees with it. But we have to put everything in context. Looking at everything that happened in the last 48 hours, the Minister of Justice, on the same day that Usainu and the sister were released a statement to point out their position. I think the right thing would have been to leave things fair, so that we don't say anything, so that sort of like undermines the authority of the courts and the credibility, the independence and the sanctity of our courts. Because when the president says that yes, we respect the courts, but we are not, we know what we're doing. We're not crazy. We're not mad people. The reason why this is the individual, that whatever, blah, blah. So you have to look at the implicit meaning of that. The president is the head of state. I don't think anybody in the country has more higher level of responsibility in terms of anything that they say. That's why in certain countries they say, even if the head of state makes certain statements, pronouncements, it is declaratory, that it has meaning in law because of the weight of what they say. Remember, this case is going to go through the appellate system, and you have the head of state speaking, and again, we have to put everything in context. Say, for example... If
you could summarize, we're running out of time.
Okay.
Just 30
so,
seconds,
for example, this was in an official function dealing with the rule of law and stuff like that, where the president reiterates respect for the courts, but say, blah, blah, blah. You can forgive certain stuff, but to make those kind of statements at a political rally, considering everything that has happened over the preceding 48 hours, has the potential to undermine the authority of the courts.
Thank you so much. Lawyer Abdoulaye Fati, Secretary General of the Gambia Bar Association. It was a pleasure having you on the program. Thank you so much for coming. Quite appreciated. Always a pleasure having you on the program. Well, viewers,
always a pleasure.
With that, we bring an end to this week's edition of your weekly State of Affairs program. I was your host, Aliou Cissé. Do join us next week. Until then, bye-bye from me and the entire team.